Mention and update this item listed items 17. You have to take it up. Yes. First you have to go to the when is your apply? Today, but go this block so it will open here. So you have to prep it down. It's right. It's for second week of September. 11th. 11 September. Yeah, 16th. Upgrading. Item 17 and 27. So you don't get it now. Your Leaderships, if I may make mention, my lords. My lords, item 23.
Yes.
My lords, this is a jail appeal, my lords. I've been appointed amicus for the appellant in this matter. My lords, this may be taken up after 2 weeks, my lords. I've talked to the other side. It's ripe for hearing.
So now it's been listed 23.
23, my lords.
It's been listed
For orders.
for orders.
Because, my lords, I believe there are quite a number of items listed before which are going to be heard, my lords.
So if it's listed for orders, what is the stage? Paper book is received.
Paper book is received, my lords.
Ah.
LCR
So
has
it
been
should
called
be
for.
listed under
Hearing, my
list.
lords. After 2
Isn't it?
weeks.
No,
Yes, ma'am.
this is concerning what case?
My lords, POXO, criminal
POXO.
jail
Then
appeal.
what about respondent number 2?
My lords,
Summons
respondent number 2
complete?
is already represented, my lords.
Represented?
Yes.
Then it should be listed for hearing, in the hearing column, isn't it?
Yes, ma'am.
Heard Mr. Jordan Rohingtanga, learned amicus curiae, appearing for the appellant, who submits that the matter has been listed for orders. However, paper book is received and both the parties have been duly represented. In view of the above, this matter is to be listed under hearing column and list after 2 weeks
Grateful.
May I please, Lordship?
and be listed after 2 weeks.
Well,
Yes.
I think, for upgradation one matter, I frame for as item number 1, item number 17, today's list, it will not take some more time from my side. So I want to leave today itself, so the first item, item 17, item 1 to 16, same matter, it will take time,
Item number
17,
17. You have a flight to catch.
Yes, yes, road conditions are bad, I'm told somebody, so.
What is the matter?
Matter, only, they asked for some rental compensation, from this rent the land was under occupation of the army from 1966, and their LSC was, 1994, 96.
Take it up.
Take it up,
Take
in
it up
the
on
next,
some other day.
Some other day.
Then, on next,
Yes.
9th of, 9th of September.
Okay, heard Mr. S.K. Medi, learned counsel for the appellant, who was prayed for adjournment of the matter, which is not objected by the learned counsels for the respondents. In view of the above, list on 9th.
9, and item number 27 of the same,
Okay, same order for item number 27.
27,
Oh, 9th is a Monday, it is a DB matter.
Because, there is only some portion, it will not take time, because Wednesday again, there are some problem,
No, we cannot, we'll make it on a Wednesday. If you can't make it, let's see, then you can think of something else.
11th.
11th. Listed on
As
11th,
a first item,
11th, 9th, so and so. Okay.
as a
Yes.
first item.
All right, okay, as first item.
Both the matters.
Both
Both the matters 11.
11.
I-
Both same order.
My lord, I would like to make a mention for item number 22 in the order.
22,
22, my lord.
yes.
My lord, I have received the paper book
Paper book.
for that and may be listed for hearing.
Okay, heard Mrs. Emily L. Sankhe, learned amicus curiae, who submits that paper book is received. And this is under which section?
30.
Under 302.
Okay, and this matter may be listed for hearing. In view of the above, list this matter for hearing after 2 weeks.
To oblige. May I make a mention, my lord? Hearing item 20. I seek your lordship indulgence in making a mention of item 29.
Yes,
My senior is having some personal difficulties, so if the matter could come up after a week.
mention is made on behalf of Mr. C. Alfonsola, learned counsel for the appellant, for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulties. In view of the above, list after 1 week.
My lord, oblige.
Lord, with regards to item number 21, in this matter, my lord, I'm appointed as the amicus for the appellant. I have already received the paper book. Can this matter be listed for
Okay,
here?
paper book duly furnished, received. This is under which section?
302.
Heard Mr. Lalramdin Thara, learned amicus curiae for the appellant, who submits that paper book is received and this matter may be listed for hearing. Accordingly, list this matter for hearing after
3 weeks, my lord.
3 weeks.
If you oblige.
For admission, item 1 to 16.
May I please, Your Lordship?
Yes.
My Lord, amongst these 16 cases, if I may first,
You're challenging the
15.
OMs, isn't it? 2015 and 10,
yes, my Lord.
So-
This item number 14, my Lord, this may be first taken up.
Item number 14.
14, my Lord, WPC
14.
number 52, 2018. WPC number 52, 2018.
Why?
Uh,
Parts of the case slightly different?
Different, my Lord, because
When were they regularized?
they were regularized on 2014.
Yes,
Item number 18.
Item number
14.
14, 1-4.
WPC number 52, 2018.
14.
WPC number 52, 2018. Item number 14. I will also address to the rules of 2020 after this. Page number 24 of the writ petition, Annex 4.
Yes.
Page number 24, Annex 4, notification dated 10th October 2008. The scheme called the Government of Mizoram Regularization of Contract Employees Scheme 2008. It shall came into force with immediate effect. Para 3, application.
Yes.
This scheme shall apply to the contractual employees under various departments of the Government of Mizoram whose engagements have been made through the duly authorized DPC with the prior approval of DPNAR and the Finance Department. Besides this, contractual employees whose engagements had been made through the duly authorized DPC with prior concurrence of Finance Department along before 6th December 2005 and whose service are still retained by executing deed of contractual agreement shall also be eligible for regularization under this scheme. This shall not apply to the contractual employees under CSS. And para 4, sub para 3, page number 25. Any person who has been continuously engaged on contract basis in the department for at least 5 years shall be eligible for regularization in the existing post against which she has been engaged, provided that such initial engagement had been done through the duly authorized DPC and she possessed the required educational and other qualification prescribed in the relevant recruitment rules. And para 7, my lord, counting of past service on regularization. The other paragraph talk about those who have continuous service of 5 years and in their initial appointment, if it is done through duly authorized DPC, are eligible to be considered for regularization. And on para 7, on regularization, past services rendered as continuous contract employees shall be counted as qualifying service for leave and pensionary benefits only. Here, para 7 provides on regularization, they shall be eligible to count their past service as qualifying service for leave and pensionary benefits. The law framers were making this
2008.
particular provision to recognize the valuable service rendered by these contractual employees prior to regularization, to recognize their past service, valuable service. And the present petitioners in this writ petition, they were initially appointed on contract basis during the period on 2009, various dates, 2009. And after coming to force of this scheme of 2008 and on completion of 5 years continuous service, they have been regularized on 2014. Different dates, but they were all regularized in 2014. However, my lord, they have been made to subscribe the new pension scheme. Now coming to the new pension scheme, which is in page number 32. Page number 32. The Mizoram New Defined Contributory Pension Scheme 2010. It shall come into force on the 1st September 2010, 1/9/2010. And Para 2.1 provides the application of the NPS. Tier 1 of these schemes shall apply only to the government servants appointed on regular basis with effect from 1/9/2010 onwards to civil service and post in connection with the affairs of the state which are born on pensionable establishments, but shall not apply to, I would like to refer to E and F. Persons employed on contract basis. F. Persons whose terms and conditions of service are regulated by or under the provisions of the Constitution or any other law or specific scheme for the time being in force. According to the petitioners, my lord, those contract regularized employees who were regularized as per the scheme of 2008, which was made under Article 309, they were excluded under this 2.1F.
Pension rules.
2.1F. And as a result of this, my lord, the state respondents had issued another notification, page number 41. The purpose of issuance of this notification in page number 41, notification dated 27/2/2012, is to include those who are excluded in the 2.1F.
Yes.
Notification dated 27th February 2012. On partial modification of Finance Department notification number such and such dated 17/6/2010. The Mizoram Defined Contributory Pension Scheme 2010, Tier 1, Para 2 shall include all master role, contract, here we are concerned with contract, ad hoc, officiating, casual employees, etc., whose services were regularized on or after 1/9/2010. Since the contract regularized were excluded by 2.1F, by way of this notification 27/2/2012, they sought to include contract regularized employees. However, this notification being an executive instruction was put to challenge and already set aside in page number 42. Page number 42. WPC number 25 of 2013. In this case, the petitioners were primary school teachers, and they were denied pension benefits under the 1972 rules. And if I may take your lordship to page 49, Para 6. For a proper adjudication of the case in hand, it is necessary that notification dated 27/2/2012 issued by the Department of Finance, Government of Mizoram should be discussed first. It is undisputed that the pension scheme of 2010 was enacted under Article 309 of the Constitution. In the absence of any denial or as regards enactment of the pension scheme 2010, it is necessary to consider whether notification dated 27/2/2012 could have been issued by the Finance Department. A reading of the notification dated 27/2/2012 clearly shows that the said notification has partially modified the pension scheme of 2010. Such modification of an enactment under Article 309 of the Constitution by an administrative order is prohibited unless sought to be done as per the prescribed procedure. The law is already settled that the statutory rules cannot be overread by an executive order, executive practice. The ratio has already been laid down by 3 bench judgment of this honorable court in the case of so and so. If it is tried that if there is a conflict between the executive instruction and the rules made under Article 309, the rules made under the Article 309 of the Constitution shall prevail. And Para 9, my lord. The notification dated 27/2/2012 clearly shows that the same was issued partially modifying the pension scheme of 2010. The language issued in the notification is by itself self-explanatory, and therefore no further discussion is required in this matter. To appointed, this question put by this court to the learned government advocate as to whether such notification can modify the pension scheme of 2010, which was enacted under Article 309. The learned GA has fairly submitted that the same is not permissible. In view of the discussions made herein above, the notification dated 27/2/2012 issued by Finance Department is set aside and quashed. The notification dated 27/2/2012 having been set aside, the next question before this court is whether the order dated 7/11/2012 issued by the respondent above 5 is tenable in law. The office order dated clearly indicates the order dated so-and-so was cancelled on the basis of letter dated so-and-so. This court had directed the land government to produce the letter so-and-so. The letter dated has been produced by the land GA before this court, which is produced herein below. And on the next page, my lord, para 12. The basis of the letter dated 16/10/2012 is the notification dated 27/2/2012. As the notification dated 27/2/2012 has already been set aside, there is no basis for the letter dated 16/10/2012, nor for the order dated 7/11/2012. In view of the above, the order dated so-and-so is set aside, and the office order 21/9 issued by the director is brought back to force. And as a result of this, my lord, subsequent to this, despite this writ petition was complied with by the respondent authority, still without preferring an appeal or review against this judgment order, they have still made regularization of contract employees in violation of this standing order, my lord. This judgment was made 28/5/2014, and even thereafter, the state respondents authority have been disobeying the direction of this court without challenging the same. Now coming to page number 63, WPC 102 of 2014. Para 6, page number 68, para 6. Para 6, this court by judgment order dated 28/5/2014 passed in WPC number 25 of 2013 had already considered the notification dated 27/2/2012 issued by the government finance department and had set aside and quashed the same. A perusal of the order dated 9/9/2014 indicates that the order was issued just after the judgment order dated 28/5/2014 was passed, and therefore the order dated 9 September 2014 stipulating that the past service of contract employees shall not be counted for the purpose of pension benefits on the basis of notification dated 27/2/2012 is contemptuous in nature. This court had already made observation that despite rendering the judgment that it will not be permissible, they were still issuing regularization order by the state respondents, even to that present writ petitioners which are still pending before this honorable court. This is against the doctrine of separation of powers, my lord. And the other day I have furnished this series of judgments. It may be in the
Item number 1.
item number 1, WPC number 14, 2017.
Yes, yes. It's there.
I would like to refer to the last annexure.
Yes.
On the side,
series of
I have flagged it
judgments.
for last
Annexure,
annexure.
annexure N,
Last.
N.
It's a letter dated, RTI letter dated 4 November 2020. The English
Yes.
translation is in the next page.
Yes.
What can be appreciated from here is that in pursuant to the judicial pronouncement of the Honorable Court, Para 2, there are 598 employees who were converted from NPS to work pension scheme.
There are 598 employees who enjoyed
my
the
lord. 598 employees were
yes.
already converted from NPS subscriber to work pension scheme in pursuant to the decision of these various judgments of this honorable court. And besides this, my lord, I would also like to place before your lordship that the manner in which this NPS is implemented by the state respondents. This is extract from one compilation. The English translation of the relevant portion is on the next page. For those NPS subscribers, if they happen to expire while in service, my lord, they were given an option that either they want to take the pension wealth under the NPS or their family can choose pension under the CCS pension rules. This was duly implemented, the process of this, which can be appreciated from page number 73 of the writ petition, which I'm referring, WPC number 52, 2018. 52, 2018.
Item number 14,
14, yes, my lord.
page.
Page number 73. Here, my lord, one of the petitioner expired, who is an NPS subscriber and one of the writ petitioner hearing. But after he was expired, his family were given an option, and they have opted this old pension scheme under 1972 rules. And I have already mentioned the other day regarding the divergent views held by coordinate single bench, and then we filed an appeal, and then after review, we had approached the Supreme Court, and now, after granting liberty to approach this division bench by way of challenging the present impugned amendment, my lord, we have all these petitions are before this honorable court, and the present impugned scheme is in page number 53 of writ petition number 52.
First one, number 1.
52.
Okay.
Item
The
number
same one.
14, same one. Same one.
Okay.
I'm referring to this item number 14 because this is one of the cases wherein the single judge had divergent view,
Okay.
wherein we preferred appeal and then we refiled this writ petition challenging the virus of this amendment. Page number 53.
Yes, page number 50.
This was notified on 27 February 2015. This scheme may be called the Mizoram Defined Contributory Pension First Amendment Scheme 2015. They shall come into force from the date of their publication in the Mizoram Gazette. It was published on my lord on the top 27 to 2015. This means it came into force from 27 to 2015. And para 3 of this amendment, it amends para 4, which states that it shall become mandatory to the government servants who entered into government service on a regular basis, regularized on or after 1/9/2010. Now, my lord, in terms of the scheme of 2008, which was made under Article 309 of the Constitution, my lord, we were entitled to count our past service, contractual service for the purpose of pension benefits, amongst other, upon regularization as qualifying service, which implies that, my lord, by referring to the principal rules of NPS 2010 2.1F, which exclude regularized contract employees. That is a settled law, my lord. And in the absence of, if we are excluded under the NPS 2010, after regularization, we have to subscribe pension scheme. And the existing pension scheme available is only under the CCS Pension Rules 1972. And my lord,
Continue.
now page number 59 of the same petition, page number 59. This particular annexure starts from page number 55. This is the affidavit filed by the state respondents in the previous writ petition filed by the present writ petitioners. And the relevant portion which I would like to place is page number 59, second para. Regarding the new defined contributor pension first amendment scheme 2015, it may be pointed out that it has no relevance to the present case because the petitioners were already regularized on 25/8/2014, and the scheme in force at regularization was the Mizoram New Defined Contributor Pension Scheme 2010. This is the stand taken by the state respondents, and it is already settled that we were excluded by the NPS 2010. And even the state respondents admitted that we were not covered by the NPS Amendment 2015. So the only scheme, pension scheme, which is applicable to the present petitioners is the scheme of 1972 rules.
So let's read the scheme of 1972 rules. That you pointed out.
1972, you have that rules with you.
You read that
Not with me
Pension
right now.
rules.
I'm sorry, man.
Opening paragraph is, this shall not apply to all those persons plus persons who are in contract.
So you're excluded. Just read
You
the
have, you
rules.
can
I don't
have this, this is
copy.
the
Give
21
him a
scheme,
copy.
21 rules, same thing. It's there in the 72 rules also. Are you given? In Mizoram, 21 is not adopted, 72 is adopted. You can come to the opening, rule 1, 2, application.
So even though you're saying that we are entitled to the 1972 pension rules, but
G,
that
have you got
excludes
G?
you.
Persons employed on contract except when the contracts provide otherwise.
My lord, now we are no longer contract employees. We are already now regularized.
No, I don't understand why you made a challenge to that exclusion. Because you were never, you can never be covered. The judgments which are there, you can never be covered in that. You would be covered. Huh? This is the new one. Old. Don't have the 72
It
rules.
will be the 72. It's only
72 rules. you don't have.
2021.
Old
year.
one. See, you can never be covered. A contract employee can never be covered by a pension scheme. It's never covered normally.
Correct,
You
my
are
lord.
covered when you are regularized,
Correct, my lord.
right?
Yes, my lord.
So the notification of the finance department, now that we are sitting in the division bench, matter is before us,
Yes,
we
madam.
can say that it was not an erroneous notification. It was correct. They said that you will be covered if on the date of your regularization. So what is the error? You are now challenging the 2015 thing.
Yes, my lord.
2015 is a continuation of 2010.
Yes, my lord, that is true.
It just clarifies that, see, persons who enter into government service after 1/9/2010 will be covered under the new pension scheme.
Yes, my lord.
Now,
That is
how
what is
can you take your date of regularization
Way back.
beyond 1/9/2010? Show me that, show us that.
My lord, in that regard, my lord, we are challenging the
Okay,
retrospective effect made.
we interfere with this. Where is that? In page number
53.
2015?
53.
Because it has
53.
taken away the vested right acquired by the
Okay,
petitioners.
what we do is, we do away with this word regularized. We say that should not be read. How will it benefit you?
Besides this, my lord, the retrospective effect given as on with effect from 1/9/2010, my lord.
Mr. Victor, this is not a retroactive effect, it's just a clarificatory thing. If
But
it is a clarificatory
It
thing,
it amended the effective date, my lord.
which one? It is only clarificatory in nature. Without this also, if you come to page 32,
32.
32. Two point one, you forget the A to F, or just forget that. Come to 2.1, that covers what is said in para 2 of 2015. Tier 1 of the scheme shall apply only to government servants appointed on regular basis with effect from 1/9/2010 onwards.
But shall not apply to. Here.
Shall not, it cannot apply to a contractual employee.
No, my lord.
72 also will not apply.
No, my lord. After regularized, if the service conditions were regulated by other provisions, my lord, this is what 2.1F,
That is what we were, your projection is wrong here.
because, my lord, since we are excluded, my lord, by way of this,
You tell me, say 2014, you got regularized.
yes, my lord.
Let's take this case. You got regularized in 2014. 2010 on, you became a government servant in 2014. You became a government servant in 2014.
Yes, my lord, correct.
I'm trying to just guide your argument. That's what madam and we were discussing, she was discussing. You cannot go beyond 2014, can you? Regularization.
After regularized,
You were regularized in 2014. That is a landmark milestone, right?
yes, my lord,
On 2014, you became a government servant. You got your scale of pay, everything.
correct.
Now show me how the 72 rules can be applied after 2010.
My lord, this impugned amendment came into force.
Let us forget. We say we quashed 2015.
Yes, my lord.
Still show me how you come in.
Yes, my lord. It is already settled by various judicial pronouncement that we were excluded by NPS 2010.
You were
Because-
not excluded because you were never within the purview. You are not in 72 also. 72 rules also you are not there. Contractual employees.
No, my lord. All other contract regularized employees have enjoyed 1972 pension rules
Before-
prior to this NPS 2010.
Huh.
And this NPS 2010 had excluded contract regularized employees under 2.1.
Were you a regular employee under the government before 2014?
No, my lord.
You
But
became
under
a-
the scheme of 2008, para 7,
Okay. When were you initially recruited? 2009.
9.
So you now want to say that my regularization of 2014 has to be construed to be a regularization of 2009.
For the purpose of pension benefits.
benefits.
Show us that. That is what you want to, we want you to argue. That your date of appointment goes beyond or prior to 1/1/2010 by applying your contractual period. Because my Lord Justice, Justice Michael judgment is the correct pronunciation of law. Was there an appeal against my Lord Justice Michael's judgment?
Yes, my lord.
What happened in the division bench?
In the judgment of Justice Michael, it had given liberty to challenge the amendment, and then in the appeal was dismissed, but
Then you-
granting liberty.
You went to
challenge.
Supreme Court.
Yes, my lord.
Supreme Court also did not
can
entertain,
challenge.
asked that you can come back. You take this. This is the 72 rules. Same thing. This is the 72, same thing.
Same. This thing.
So you come to the 2008 rules once for a minute, 2008. Page 25, para 7.
Yes, my lord.
On regularization, past services renders as continuous so-and-so shall be qualified, counted as qualifying service for leave and pension benefit. It does not speak anything about a pension rule here.
That
It
is
says-
correct. That is correct.
Pensionary benefits would be given. Same thing if you are entitled under the NPS, you will get it.
No, my lord. The difference.
Because we'll have-
irrespective of the difference of the benefits under the NPS and these 1972 rules, my lord.
You show me a service of yours when the 72 rules were in currency. That's all. I'm not against you. I'm
Yes, ma'am.
trying to be with you. Show me. Show us that part. That, see, because of this, my service has to be deemed now to be under the covered by the 72 rules.
What was the reply to your RTI application that some persons have been enjoying?
598,
5 to 98 persons.
in compliance with the judgment order of this court.
Oh, that.
We are similarly situated with
But
those
what is
persons.
when were they appointed, when they were regularized, all
All,
those
all
598?
between 2010 and 15. We are similarly
There's a
situated.
lot of inconsistencies going on. Some of them have enjoyed, some of them are not enjoying.
Direction of this. This is wrong. This is an
The
illegal.
reasons of all these conversions were that we were student under the NPS 2010. And once we are student under NPS 2010, the only pension scheme available is
Wait.
1972 rules.
Here's a picture. No, wait.
Now, in the, yes. You see, because some people have
This-
enjoyed and some people have not been given, that's the whole thing. Let's have a look.
No, the compilation. Black
Wait,
mark.
wait. Now, if you come to the compilation, which you have just
Yes, my lord.
mentioned,
Yes, my lord.
the RTI reply,
Yes, my lord.
so read the Mizo, the one in the vernacular language, not the,
Yes, my
not
lord.
the English one, to see whether it's properly translated as it's supposed to be.
Madam wants you to read that
So
original
here
vernacular.
it says that as per the original,
Yes, my lord.
okay,
Government of Mizoram Lawyer Department from Changa Contract Employee Regularada NPS Mantiza Thi kan office High Court ani Roman Atelo. High Court akin ne avanga NPS Changa Organ Sanal let chu mi sanga sumpo pare tandi.
so this is because of the High Court judgment of the High Court, direction of the High Court. Many of them have opted again for the old pension scheme. It isn't
And-
it? As many as 598.
Yes, my lord.
So that's the. And then you have the judgment. So the apex court, the apex court should have taken up the matter because a lot of conflicting opinions in the judgments of the single bench.
My lord, all these single bench judgment order which resulted in the conversion of these 598 employees is in pursuant to the direction of these 14, 10, 11 cases. They were all complied with. The petitioners, they really were regularized during the period between 2010 and 15. Us also, the present petitioners also.
The trouble is that even we find that there is some wrong interpretation, they have not been challenged and steps have been taken as per the direction of the High Court.
Now we are sitting in division.
We can make the correction. And what was done wrong before? may
If
not
I
be
may allow to
followed
say
at the
so.
time. But we have to listen. Yes, give your
If
submissions.
this
Yes.
of the record, if I may allow to say so, these about 10 cases were disposed by Justice Jamil, Justice M.R. Pathak, Justice Michael, Justice Sumansiam, all in favor of this.
But they all are single benches.
Yes,
Isn't
my
it?
lord.
Now the
And
matter has come
Though,
up
though
before the
two matters
division
were,
bench.
were challenged before the division bench in the principal seat, that were also dismissed.
So none of the judgments have been challenged before
Yes,
the
my lord.
division
It has
bench
been
right now
finally-
also. It is just the rules that have been challenged.
Yes, my lord.
Isn't
And
it?
now,
So the judgments are still as it is. They are not challenged. That's the whole thing. Anyways.
and now the amendment
uh,
saying that
Deeper thought into the matter. Yes, please, we will hear you out. We will hear the Learned Council, government also, and then we will give it a deeper thought instead of coming to a decision right away. Because a lot of waters have flown under the bridge. Things have happened. Okay, and ultimately now you come and challenge the, the rules, 2015.
Asking also to 2022.
Yes, and please address the 2020 rules also. Okay,
just
so
before
then,
that, if
yes,
your lordship
yes,
permits
please
me,
continue, huh?
just before that, if your lordship permits me.
Yes.
Now, the first judgment which I've been reading again and again, this WPC number 25 2013, this portion 28 5 2014, it held, as it is, it held that contract regularized employees were not covered by NPS 2010. So they were made to subscribe 1972 rules. And even after enactment of the present amendment 2015, which is being challenged, the single bench, it was already brought on record before the single bench in those already disposed case. But the learned single judge was of the opinion that they were still not covered by the amendment. But due to the divergent view of another judge, this is being challenged. And now, taking that the NPS 2010 is not applicable to the contract after regularized. If that is so, my lord, they have already acquired their vested right under the pension rules of 1972. But by way of this amendment, which was notified on 27/2/2015, had it been made prospective, we may not have any grievances. But as a result of the retrospective effect, it has taken away the vested
By the
right of the
judgment.
petitioners.
That is the 72 rules. You have the 21, that is the 72 rules. You are not covered by that also.
My lord, prior to our regularization, we are not covered by this. We agree that
What different language is used in 2010?
then,
It's the same language that is used in 2010.
Contract employees are not
Contract
covered.
employees not covered.
we will
Finance
not,
department says once you are regularized, you are covered. 72.
I understand, my lord. My humble submission is that in terms of 2.1F, since those services which were regulated by another provisions, they were excluded. And we were regularized under the scheme of 2008, which is also Article 29.
We'll clarify to that
I
extent.
think we need to read the reasoning made by the single bench judges.
The reasoning is, Justice Michael's reasoning. You can just go through that.
Let's look at the reasoning made by the
Here
learned
there is
single
nothing.
bench.
Other judgments, unfortunately,
Okay.
it's wrong. Michael, this is Michael. Not it.
Even with,
Government has
and
not come up.
right now also it's not being
No,
challenged.
no. Government has not come up. If you come to this,
This is in
this is in
E what?
this WPC, this is J.
J. So let's look at the reasoning.
If I may take a lordship once again to this compilation of judgment, Annexure D.
Just now.
Yes, my lord, I'm sorry.
So let's look at J.
J.
Okay.
J.
Judgment made by Justice Michael, where it says that retrospective effect
Para 11.
is to be given to the what the rules 2015, isn't it?
Para 11. Mr. Nelson,
Yes.
so cannot be made applicable who were regularized prior to the limits that so cannot have a retrospective prospectively. So that is also replaced.
Para 21.
This is the submissions one. Points are at page, issues are at page, para 13. This is exactly what he's trying to do.
There's the first issue.
The second issue was taken up first.
It's been taken up first. And then
Refer to a division bench judgment. Now the rules come up. He considers para 15 rules, he considers the rules. Continues. This is what they are claiming. Para 15 is what they are claiming. His reasoning is here. Would have to be in accordance with the pension rules scheme at the time of regularization of the contractual. It is submitted so and so. The petitions were not covered by the policy transfer of the case. Also, not a pension. The right of the petitioners came only at the time contractual employees became regular government servants. Have been regularized only after so and so. The
cannot
petitioners have
claim to be governed by the
372 rules also. Para 16. Accordingly, in my view, so and so has to be given an interpretation. Past service shall be counted as qualifying service. So and so at the time of regulation, which is the 2000. For example, so and so 2008 was very
So this is a judgment, but then there are other judgments.
He has considered that also. Para 70. 25, 2013, he has considered. And then,
See, but this was before the 2015.
this was
Rules,
after the,
isn't it?
no, after the 2015 rules.
No, the previous judgments.
Or 25 and all were before the, then
Quite a
when
few of the judgments, then just a,
prior,
ah,
19, para 19, he deals with it.
those were different.
Yeah,
They came
yeah.
later, yeah.
Due to the reasons stated, differs from the judgment. So and so, so and so. Then he discusses 15. He rules that 15 as a retrospective.
So if we have this judgment,
He only
which
makes,
says that it has retrospective
what he
effect,
in the last part, paragraph, he says that it has not been challenged. So they have not challenged it. Otherwise this reasoning is founded on both the rules. applicability in 15 scheme.
So the writ petition was dismissed.
Because here he says the other petitions which have been decided by single bench of this court and which have been referred in this judgment have not gone into the question of applicability of the 2015 amendments. So this is the first judgment wherein that amendment scheme was considered and it was said that it would be given a retrospective. It has a retrospective. The wording itself shows that it covers all this.
And this judgment itself has not been challenged, or was it
This
challenged?
was challenged.
This
It
was
went up to the
challenged,
Supreme
yes.
Court. It was not.
But nothing
But the Supreme
decided.
Court said no, so nothing decided. Supreme Court said that
Ultimately, we have to challenge, and he's come before the court
Yes.
challenging, yes. So I think we can decide the matter. Yes,
ask about the 2020.
so I think we have got your point. Okay. But what about the 2020, the latest one, which clarifies, it seems, everything?
And before you submit, the 2008 was a scheme, not under 309.
It's under 309, my lord.
309.
Yes, ma'am. That is the reason we
Okay.
place a line.
This one is also under 309.
And when there are two schemes made under 309,
You-
the beneficial side should be taken. It's
You-
a settled law,
You satisfy us on this 2020.
2020.
You see, we will look into 2020, but the old pension scheme seems to be excluding you also. You're saying that we have to have the benefit of the old pension scheme, but the old pension scheme does not appear to include you.
My lord,
That little portion, if you can,
my lord,
yes, you see.
contract employees were not included under the 1972 rules. But when
So
contract
as
employees,
long as you were the contract employee, you were not included. Only after being regularized,
Correct.
you are included, isn't it? So now you're trying to count your past service while you were also the contract employee. So your interpretation of this application, the pension rules, you're trying to interpret it to your benefit.
my lord,
But on
assuming,
reading of the rules, it does not seem to include you, though you're saying that we should be included.
my lord, assuming that the NPS 2010 rules is not available,
Okay,
the only rules, pension rules entitled by government employees will be the rules of 1972, as they have done. And now,
but after they are regularized,
yes, my
from
lord,
the date of their regularization,
Yes, my lord.
without counting their past services as contract employees.
but the scheme of regularization of
what-
2008,
Black and white. See,
2008 scheme, which was made under Article 309, it provides that it can be counted as qualified service. That is the only reason. And on the basis of this,
No issue. If there is any lacking, that will be counted. But how can you be brought under 72? That you satisfy us. We are not getting an answer to that one.
now, my lord, it was already
supposing
held,
2008 rules was not
my
there.
lord. It-
Supposing, okay, you're saying supposing 2010 was not there, then supposing 2008 rules were not there, then what happens?
we will never be regularized. We will remain being a contract. We were regularized under the scheme of 2008, which was made under Article 309 of the Constitution. And Para 7 provides that on regularization, the past contractual service can be counted as qualifying service for the purpose of pensionary benefits, amongst other. Meaning thereby, my lord, now it was already settled that NPS 2010 exclude us.
So you're trying to rub yourself into the old pension rules, because of that it's clause 7. Okay,
Yes, my
got-
lord. Yes, my
I got
lord.
your point, huh?
Yes, madam, because it is made under Article 309, and it was already settled that NPS 2010, the original pension
And
scheme,
many people have
exclude
been
us.
enjoying, okay, yes,
And now, if they try to brought under the NPS scheme, under the amendment 2015, while the other scheme provides beneficial legislation provision under the scheme of 2008, it cannot be taken away by another provision. That is a settled law.
Okay. Both under 309.
Yes, my lord. The beneficial side should be given.
It's unique.
Yes, yes, go ahead.
Rules of 2020.
Okay.
What is meant by qualifying service? What do you mean by qualifying service? You have been emphasizing
Yes,
on the
my
word qualifying service.
As we came across all these rules, my lord. During contract period, before regularization, we are not entitled to pension establishments and under any provision of law. But under Article 309 of this scheme of 2008, we were granted these entitlements.
No, that's what that word, that line I'm expecting from you. What happened? What is that great thing in 2008 scheme
My lord,
that entitles you?
under the government of Mizoram, my lord, there are various temporary employees on different nature.
I got it.
And only these contract employees have regularization scheme which provide these benefits. The other
How?
master
How?
role
How?
employees,
How?
ad hoc employees, they do not have.
How? Means, what is that great thing? That's what I want to understand from you. I'm not getting that. I've been asking you that.
My lord,
Because there is two schemes now.
Yes, my lord.
1972 and 2010. You forget the things. If you have become a government servant in 2014,
yes, my lord.
you are under the regime of the new pension scheme, right? Forget 2008, para 7. You are in the regime of the new pension scheme. Now, 2008, we add another element to that puzzle. Now, when you add that 2008, para 7, what happens? Why should we?
Yes, my lord.
Why
Under-
should a contract employee get it? That
Yes, my lord.
answer you give me.
Yes, my lord. There is this NPS scheme 2010. And under 2.1F,
Sorry, that is not the answer.
under 2.1F, it says that
You are excluded.
those persons would be excluded. whose service
72
will be
rules also says the same thing.
No, my lord. That is during contract period.
Well,
Now-
2010 is also during contract period.
No, my lord. That is different, my lord.
Come.
This 2008.
Come,
this-
come, we are now there. Come there, page 32. This is the application of the scheme, right?
32.
32.
Yes, my lord.
19/2010 2F, which shall not apply to E, persons employed on contract basis. Now you come to the 72 rules. Mr. Victor, we understand. You come to the 70. We will have to write the judgment. We will have to understand your point. 72. It also excludes you. Contract. Right?
Yes, my lord.
Now you come to the that notification of government, finance, page 41.
Yes, my lord.
Okay. Here it says, shall include all, etc., whose services were regularized on or after 2010.
Yes, my lord.
So, the government in this notification says, moment a ad hoc employee is regularized or a contractual employee is regularized, he will be brought under the scheme. That is pension scheme, that is the new pension scheme.
Yes, my lord.
No error in this. There can be no error.
My lord, this was already set aside.
Fine, fine. We are now in the writ appeal. We have two judgments before us. Now you come to the 53 scheme, page 53, 2015.
Yes, my lord.
Now you see the language change here. Para 2, amendment of para 2. So this para 2 in 2010 scheme is undergoing a change. You come to E. Persons employed on contract basis who are not regularized. It shall not apply. Right?
Yes, my lord.
How will it apply? That is next, amendment of para 4. right? It shall become mandatory to government servants who entered into government service on regular basis, regularized on or after 1/9/2010. So clause 2 and 4 of the original scheme was substituted. Now come to original 2 and 4, page 34. It shall become mandatory to government servants who entered into government service on regular basis on or after 1/9/2010. What is the difference in the effect in the amended provision and the unamended provision? Nothing.
Nothing. That is the reason, my lord, that I pointed out.
They just used a clarificatory word, regularized.
Yes, my lord. That
So
is the reason.
that itself shows that this is a clarification to the provisions of 2010 rules.
That is what I have mentioned, my lord. After this amendment was notified, there were several writ petitions disposed of in the same line, because
WPC 25 onwards.
onwards, because
But
they were of the opinion
in those writ petitions,
yes, my lord.
other than the writ petition wherein you went up on appeal and Supreme Court, 2015 scheme was never considered.
Yes, my lord. Now, this 2015 scheme, my lord, as your lordship had already pointed out, it makes no difference with the language, the effect, the impact.
So I'm asking you,
Yes, my lord.
what is your grievance? I'm not still getting what I want from you. We are expecting something, but we are not getting it.
All right, my lord. Now, the settled law, as on today, is that in by these various judicial pronouncements, my lord,
Okay, I'll ask you this
yes,
straight.
That's what they have come with.
Do you want your service from 2004 to 2014 to be counted as a regular service, to treat it as your appointment, regularization in 2014, to be deemed, I'm using the word deemed, in terms of para 7 of the 2008 scheme, to be an appointment of 2004?
yes, my lord. Only for the purpose of pension, as provided under the clause
Tell
7.
me, now, I've given you, now explain. How?
Because, my lord, this NPS 2010 2.1F excluded, if I may take your lordship again, to that
So there is a
2.
decision against you of the honorable, of our principal bench, my Lord Justice Debashish Borua. Same point.
If I may take your lordship again, 2.1F. Persons whose terms and conditions of service are regulated by or under the provisions of the
That will
Constitution.
not applicable to you.
Because,
You will be E. It will not be F.
no, my lord, that is before, E is before regularization.
Because why I'm saying so,
We were not covered by this
why I'm
E.
saying so, if E and F together cannot go together, mean the same man, because it would be just incongruous, because contract basis and this will not be covering.
We were no longer contract, my lord. Now we were regularized. And we were regularized under
You
the
were
scheme of,
in 2010, you were contract.
that is correct. And we were regularized under the regulation scheme of 2008, made under Article 309.
Okay.
And our
Come to
terms and conditions of
come to
service.
your regularization, page 26.
Yes, my lord. As per the Government of Mizoram Regularization of Contract Employees Scheme 2008.
Read further.
Further,
As amended from time to time.
Yes,
by
correct.
committee.
at this point of time, 2014, this clause 7 remains the same as pension and leave.
Okay, we will say that your contractual period will be taken for leave and pensionary benefits. If you have a shortfall, that will be added. I told you the other day also, show us a law, a judgment, which says that this is permissible. By adding that service, you, in effect, 2014 is taken to 2009.
not only because of this, my lord, scheme of 2008 clause 7. In addition to this, my lord, 2.1F, it excludes those service terms and conditions
You're
regulated
again
by
going back
other
to the same
constitution.
thing. You're again
So,
going,
but
going back
if
to the
you're
same thing.
excluded, you're
You are excluded from
excluded.
1972 also.
No, my
You're
lord.
Then you
No,
will
my
tell
lord.
me you regularized.
No, my lord.
That is there in the 2000 notification which was set aside by this single bench and the 2015 scheme. You recollect your thoughts, you rearrange your argument. We'll hear the comment. I've given you a line. You just try to work on it. Sit down. Coolly you think, give us an answer. We'll hear Madam till
Yes,
then.
my lord.
Yeah, please, Your Lordship.
You come out of that, don't go in that
You see,
contract
saying
covered,
that you
not
are
covered thing. That is what,
excluded does not mean that
That-
you
that-
should
that-
be included.
that will not help you.
You see, you read the language, it simply mentions that you are excluded. If you are excluded, then how can you say that you are, since you're excluded, you should be included in this? You see, how are you trying to,
Well, my lord,
you
yes,
know,
yes.
bring yourself inside
Once-
within this scheme?
once-
That's what we are not
once-
understanding.
I'm excluded from NPS 2010. What am I entitled?
You are also excluded from 72.
No, my lord.
Yes.
They have excluded contract portion.
Contract, so
Those
you
who are,
also-
those who are on
now,
contract, those who are on contract.
anyways.
Mr. Victor,
yes.
that 2010 also is exclusion not of a contract employee, but the contract period. Both same. And that is the error, according to us, in the WPC number 25. And that was rectified in the subsequent single judge judgment of my Lord Justice Michael. Now you think, sit down and think. Yes, madam.
My Lord, if I may be allowed to refer to item number 1, WPC 14 of 2017.
Yes.
My Lord, the new defined contributory pension scheme 2010. My Lord.
Yes, that's
The new pension scheme 2010 has come into force on 1/9/2010, which has replaced the old CCS pension rules, the 1972 rules. So for the time being, my lord, we have only one pension scheme for all government servants appointed on regular basis with effect from 1/9/2010. And my lord, reading of the new pension scheme, it's in a very clear and unambiguous term, my lord. At page 10 of my affidavit in opposition, this is the new defined contributory pension scheme of 2010.
Same.
At page 12, my lord, the salient features of the Mizoram new defined contributory pension scheme 2010.
Yes.
This scheme has been introduced to replace the existing defined benefit pension scheme under the existing Central Civil Services Rules 1972 with effect from 1/9/2010. It shall become mandatory to the government servants who entered into the government service on regular basis on or after 1/9/2010. So, my lord, this has when this pension scheme was introduced, my lord, it has taken away the rules, the CCS pension rules of 1972, and this is the only pension scheme that is available after 1/9/2020. And this, my lord, this is very clear. There can be no other interpretation. The rules of 1972 has been done away with after introduction of this scheme. And the petitioners, my lord, they're all on contract basis, and they were regularized under the 2008 scheme. That is after the introduction of this new pension scheme. And so, my lord, they are all covered under the new pension scheme of 2010. And they have to be governed by the rules and scheme which were prevalent at the time of their regularization. And since the new pension scheme was the only pension scheme available, they are bound to be under the new pension scheme of 2010. And my lord, the plea that they have taken that para 7 of 2008 scheme, that their past services rendered has to be counted as qualifying service for leave and pensionary benefits. My lord, this para 7 of 2008 scheme it cannot only relates back to the CCS pension rules. They were never governed by any pension rules because their employment as contract was not a pensionable post at that time, and no right has accrued to the petitioner to be governed by the CCS pension rules.
Yes, but quite a few persons, as many as 500 something.
My lord, with regard to that,
persons,
the facts are different. My lord, I'll take your lordship to the judgment which has been passed by Justice Michael Zotam, dated 1/10/2015 at para 17.
Yes, go ahead.
Para 17. I have read the judgment passed in WPC number 25 of 2013, WPC 93 of 2014, WPC 102 of 2014, WPC 8 of 2015, and WPC number 12 of 2015. The facts of the above cases in general are to the effect that the petitioners were contractual employees and their services were regularized after the 2010 pension scheme was introduced. The learned single judge in the above cases has held that para 7 of 2008 regulation scheme, having stipulated that the past services rendered as continuous contract employees shall be counted as qualifying services for the purpose of leave and pensionary benefits. The petitioners who were contract employees prior to the coming into force of the 2010 pension scheme would be liable to be governed by, under the CCS pension rules 1972, as their past service has to be counted for pensionary benefits. The learned single judge has also held that in view of clause 2.1f of the 2010 pension scheme, the contract employees on regularization were to be governed by the CCS pension rules 1972. I have also noticed that in WPC 93 of 2014, the petitioners in that case have placed reliance upon the judgment and order dated 23/7/2014, passed in WPC number 46 of 2013, to support the argument that officiating appointment of a person who was regularized after the 2010 pension scheme came into force would entitle the persons to be governed under the CCS pension rules 1972. A perusal of the judgment and order dated 23/7/2014, passed in WPC number 46 of 2013, shows that the fact situation is different vis-a-vis the present case, in as much as the petitioner in WPC number 46 of 2013 had been appointed initially as a meter reader on 31/5/1983 and appointed as junior engineer on officiating capacity in the Power and Electricity Department on 15/9/1998. The petitioner in WPC number 46 of 2013 has also been allotted a Provident Fund account number PAE 1517 since 1990 to 1991. That is long before the 2010 pension scheme
Madam, we
had
have
come
got
into
it,
force.
we have got it.
Yes,
But
my lord.
what my lord was asking you was whether those 598 persons in that
Yes.
RTI reply is the petitioners in this cases or beyond this also? Because there is no material. Why have you done it on pick and
It's
choose
just in
basis?
numbers.
Why have you done it on pick and choose basis?
It's not pick and choose, my lord. It's because of the judgment of the.
Why have
learned
you not
single
gone
judge.
up on appeal? Because those judgments literally went against you, your scheme. It entailed a financial burden on you.
My lord, at that time, if I'm not mistaken, we had filed an appeal in some cases, but the problem is the department, they have complied in some cases. So the council in
So you
the
give it to
principal
them,
seat
no.
has withdrawn his cases, so.
You're
we could not
giving
do
benefits to some persons while refusing the same benefit to other persons. You see,
No, my lord, that is why we have come up with this notification, the amendment to clarify the scheme and the rules.
Now you come to your 2020 scheme. Show me that they are covered by that. Mr. Victor has not argued on that, but we can ask him. 3D.
At
You
rule 8,
just, madam, read that.
which one, my lord?
3D.
3D.
3D of 2020. Madam, this is interesting. Just read it. Contractual.
3D.
3D.
Contract employees initially engaged before the commencement of the Government of Mizoram Regularization of Contract Employees Scheme 2008 notified Vite Swenso dated 10/10/2008, which came into force on 10/10/2008.
So this is with regard to persons who were engaged prior to 2008
Yes.
scheme. But these petitioners here were all engaged after 2000. What would be their status in terms of this 2020?
In terms of that, my lord, at Rule 8, it's written counting of past service for pensionary benefits.
It again goes back to 2, and 2 will have to take you to 3. So what is the stand? What is the position with regard to appointees under that scheme after 2008? After that scheme had come into being?
This is also not under challenge.
This is also.
2015 is challenged, but
Because
you're
here,
aware of this?
Madam, you see 3D, it says contract employees initially engaged.
Yeah.
3D. Before, it says before. Contract employees initially engaged before the commencement of the government so-and-so, notified right so-and-so, which came into force so-and-so. So what about the people who were appointed thereafter? Clause 5 will clarify anyway. Yes, madam.
One-third
You
of
have
them.
not provided for that. We will have to infer that.
My lord, prior to this also, we have made certain amendments to the
Again,
scheme.
how long will you continue making amendments?
2020 has been amended.
Amended.
No, my lord. I mean, the pension scheme of 2010 has been amended, and the 2008 regularization scheme has also been amended.
Where are the amendments? 8-2.
You can come to 8. That will help you to breathe a little bit more freely.
Yes, so those who are after will not be counted. Look at 8-2.
8-2 is there, my lord, yes.
So will this cover them also?
Yes, my lord.
How? Just give me a reply to that.
My lord, it's clearly written here, my lord. Past services rendered by employees under the government of Mizoram, as specified under Rule 2, who were appointed as regular employees after the commencement of the Mizoram New Defined Contributory Pension Scheme 2010, that is 1/9/2010, shall not make such employees eligible to get pensionary benefits under CCS Rules 1972, including gratuity.
But ma'am, when you say that, 2, generally they are covered. Everybody is covered. But if you come to 3, opening paragraph of 3,
Para 3.
para 3,
Past services rendered by work charge employees shall be eligible to be counted as qualifying service for determination of pensionary benefits under the corresponding
no, clause 3. That means rule 3.
Rule 3.
Rule 3, eligibility for counting of past service.
Yes. Work charge, contract, provisional, or any ad hoc officiating employees as specified under Rule 2 of these rules shall be eligible for the benefits provided under these rules upon fulfillment of the following conditions.
One is okay,
One is
Two
there
is
is no
okay.
pay.
three.
Three,
Candidates were initially recruited on recommendation of the relevant department with the exception of. So persons who are there beyond, okay,
This is the pass.
counting of past services.
NPW.
so now it has been made subject to now only for the purpose of the
Yes.
past services for the need.
This is only for past services, my lord, not for
One
pension
third of the
benefits.
past service will go for promotions.
So, no, this has something to do. So you're not, they're telling you 2015, but not.
Not the 2021, 2015 is just a scheme. 20 is the rule, this will hold it.
Now, Mr. Victor, you're not challenging the 2020
No, my lord. We do not challenge.
rules?
If
So-
your lordship may come to saving clause.
Saving
Rule
clause,
eight- Rule 10.
okay, yes. What does it say?
Counting of past service as approved by the government in the DP and AR before the commencement of these rules 29/5/2020. In any manner other, those specified in these rules shall not be invalidated after coming to force of these rules.
Show me how much one-third calculation, how much period of yours were taken, where is that notification? In your case, individual. It says counting of past services approved by the government in the department of so-and-so before commencement of this rules. That will be pertaining to an employee concern.
My lord,
Very-
this word past service, counting of past service, this is a blanket sentence. It covered past sentence in the manner of pay, higher grade, or pension benefits, whatever. So, my lord, when we were regularized, the scheme of 2008, it was made under Article 309, and only after duly approved by the duly constituted DPC and the DP and AR, we have been, our status was already settled before commencement of these rules, which came into force on 29/5/2020.
No, you come to rule 8 of that rules.
Rule 8.2 speaks for itself, my lord, but we are under the
No,
10
you are
saving clause.
covered by 8.2.
But
You are covered by 8.2.
there's a saving clause under Rule 10, my lord.
So how are you covered by this? Counting of pass as approved by the,
My lord, the rules of,
has it been
Why
approved?
is this wording used that approved by so-and-so?
Has
It
it
could
been
have been
approved?
said 2008 rules.
this is a blanket statement, my lord. It covers everything.
Then it would have been more blanket if they had said that 2008, whoever has been regularized under that, saved. We are not touching. But the whole reading of the rules does not show.
No, my lord. The rules of regularization scheme 2008 provides the manner in which regularization can be done. And the scheme under clause 7 provides the qualifying service for past service. And only after that is duly approved by the competent authority, we have been regularized, entitled, and able to enjoy all the benefits provided thereunder. It was already settled our case before the commencement of these rules, which came into force on 29/5/2020.
Any Supreme Court decision you want to rely? Or our High Court decision in your support of your submission?
On which point, my lord?
On this point that you are entitled.
No, my lord. Because our service, we have been regularized under the scheme of 2008, made under Article
So
309.
in all the pending writ petitions, you were regularized? When were you regularized?
After 2010.
After 2010?
Yes, my lord.
You have any statement to that effect?
Or
Statements?
because, yes, because in the first one, that is 14.
16. Revised in 16.
Okay, you were regularized in after the 2015.
16. this scheme of 2008, that rules, still in operation?
My lord, it was amended.
When?
It's amended on 30/7/2015. It's in
To the extent?
page 17 of my affidavit in opposition.
I'll apprise the court in that regard, my lord. This NPS amendment was 27 February 2015. And thereafter, the regularization scheme was amended on with effect from 10/8/2015.
Where is that? Okay, page 17.
Page 17 of my affidavit, my lord. Amendment of para. In para 17, 7 of the principal scheme, the following shall be substituted, namely, on regularization, past services rendered as continuous contract employee shall be counted as qualifying service for leave only. So this is, my lord, clarificatory
leave
in
only.
nature.
So
And it
this has
should
now
have a-
been reiterated in 2020 scheme.
And it should have a retrospective effect because it's
this-
clarificatory in nature.
No.
I have a judgment in that regard. my lord.
Okay, complete your submissions first. They were coming out in bits and pieces. Yes.
I have a judgment, my lord, 2018, volume 17, SCC 394.
2017,
2018, volume 17, SCC 394. From para 33,
Now we have it here. Yes.
Oh.
Para
33,
33. We are supposed to have
33 onwards.
why not you?
but it's a bit difficult to have it.
Para?
33, my lord.
Then if you can enlarge the script.
Married, my lord.
Wait, let's beyond the yes. 32, para 33, yes.
The report of the said committee makes
Can you
it clear.
enlarge it somehow? Okay, it's okay, yes.
The report of the said committee makes it clear that the object of the amendment was to clarify and set at rest what the committee thought was an overbroad interpretation of section 14. That such clarificatory amendment is retrospective in nature would be clear from the following judgment. 33.1 CIT versus Shelley Products. It was submitted that after 1/4/1989, in case the assessment is annulled, the SSC is entitled to refund only of the amount, if any, of the tax paid in excess of the tax chargeable on the total income returned by the SSC. But before the amendment came into effect, the opposition in law was quite different, and that is why the legislature thought it proper to amend the section and insert the proviso. On the other hand, the learned counsel for the revenue submitted for that the proviso is merely declaratory and does not change the legal position as it existed before the amendment. It was submitted that this court in CIT versus Titor Electric Supply Corporation has held that proviso A to section 240 is declaratory, and therefore proviso B should also be held to be declaratory. In our view, that is not the correct position in law, where the proviso consists of two parts. One part may be declaratory, but the other part may not be so. Therefore, merely because one part of the proviso has been held to be declaratory, it does not follow that the second part of the proviso is also declaratory. However, the view that we have taken supports the stand of the revenue that proviso B to section 240 is also declaratory. We have held that even under the unamended section 240 of the Act, the SSC was only entitled to the refund of tax paid in excess of the tax chargeable on the total income returned by the SSC. We have held so without taking the aid of the amended provision. It therefore follows that proviso B2 section 240 is also declaratory. It seeks to clarify the law so as to remove doubts leading to the courts giving conflicting decisions, and in several cases directing the revenue to refund the entire amount of income tax paid by the SSC, where the revenue was not in a position to frame a fresh assessment. Being clarificatory in nature, it must be held to be retrospective. In the facts and circumstances of the case, it is well settled that the legislature may pass a declaratory act to set aside what the legislature deems to have been a judicial error in the interpretation of statute. It only seeks to clear the meaning of a provision of the Principal Act and make explicit that was already implicit. And
Well, this is basically justifying the amendment.
my lord, in 33.2, the second para, the presumption against retrospective operation is not applicable to declaratory statutes, as stated in Crease and approved by the Supreme Court. For modern purposes, a declaratory act may be defined as an act to remove doubts existing as to the common law or the meaning or effect of any statute. Such acts are usually held to be retrospective. The usual reason for passing a declaratory act is to set aside what Parliament deems to have been a judicial error, whether in the statement of the common law or in the interpretation of statutes. Usually, if not invariably, such an act contains a preamble and also the word declared as well as the word enacted. But the use of the words "it is declared" is not conclusive that the act is declaratory. For these words may at times be used to introduce new rules of law, and the act in the latter case will only be amending the law and will not necessarily be retrospective. In determining therefore the nature of the act, regard must be had to the substance rather than to the form. If a new act is to explain an earlier act, it would be without object unless construed retrospective. An explanatory act is generally passed to supply an obvious omission or to clear up doubts as to the meaning of the previous act. It is well settled that if a statute is curative or merely declaratory of the previous law, retrospective operation is generally intended. The language shall be deemed always to have meant is declaratory and is in plain terms retrospective. In the absence of clear words indicating that the amending act is declaratory, it would not be so construed when the pre-amended provision was clear and unambiguous. An amending act may be purely clarificatory to clear a meaning of a provision of the principal act which was already implicit. A clarificatory amendment of this nature will have retrospective effect, and therefore if the principal act was existing law, which the Constitution came into force, the amending act will also be part of the existing law. So, my lord, we have clarified the existing scheme and the rules by way of amendment.
Yes. I think we can, anything else to submit? We will make it a CAV. We'll mule over your arguments. Heard me.
My lord,
Anything else? Yes.
although I have already provided this. My lord,
Yes.
that are different. That piece of paper,
Yes.
if you also may see the particulars, the numbers of the petitioners therein, already disposed, which was already complied. And in addition to that, there are some other two petitions to show that 598 employees were converted from old pension to NPS. And my lord, the list which I, this serial number 1 to 7, the first page, they were regularized prior to amendment, NPS amendment 2015. Page 1, serial number 1 to 7, they were regularized before amendment of NPS 2015. And on the next page, my lord, second page,
The second page of what?
No, ma'am.
I have only one copy, this one.
Yes, refer to that.
On the first page, my lord, this serial number 1 to 7 with petitions, they were regularized before 2015 amendment, NPS amendment.
Yes, yes.
And serial number 8, 9, and 10, after amendment of NPS, but before amendment of regulation scheme, because the manner in which challenge was made are different in these petitions, my lord. In those who were regularized from serial number 11, we have challenged two schemes.
Okay, heard, Mr. Victor L. Rante, Learned Counsel for the petitioner. Yes, Mr. Are you finished? You're finished with your submissions? I interrupted you right now while you were saying something. Yes.
I just want to refer two judgment only.
Yes, let him
From the
give
compilation, I have
satisfaction.
submitted
Yes.
list of judgment.
That we will take care.
Only-
are the
only
judgments
two
you want
judgment,
to
my lord.
refer to? He wants
If you're
to
lost in
point out the
mechanism.
two judgments, yes.
Give the WPC number.
Flex C,
Flat C.
WPC?
WPC number 46, 2013.
Ah,
This was judgment order dated 23/7/2014.
that is the case wherein they had a master role, then junior engineer, then.
Yes, my lord. The learned single judge, my lord Justice Michael had make differentiate of this, but they're different. And at Annexure D, WPC number 93, 2014.
This has also been taken care of, dealt with. in
Para
the subsequent-
34, para 34. (2016), Volume 7, SCC, page 703, para 61. Last sentence.
Yes.
The reasonableness of the restriction and not of the law has to be found out. And if restriction is under one law, but countervailing advantages are created by another law passed as part of the same legislative plan, the court should not refuse to take that other law into account.
Yes, some more citations?
And
We just introduced it recently, okay? Yes.
the amendment of regularization scheme 2015, not the NPS, the regularization scheme 2015, the amendment, which was referred by my learned friend. Your Lordship may kindly notice that this honorable court had already held that they were entitled rule of 1972 as a reason of clause 7 of the scheme of 2008,
2008, yes.
since they were excluded under this. Well, that is in force, my lord, without challenge. They have made an amendment saying that if that is given retrospective effect, that will be against the doctrine of separation of powers, because that is intended to nullify the judgment which was already rendered and complied by the respondents themselves. And lastly, but not the least, till date, my lord, including the present petitioners and those other government employees of the state of Mizoram who were the subscribers of NPS, as I have placed earlier, in case they expired while in service, they were given CCS pension rules 1972.
That is a beneficial thing. Even if we go against you, we will not touch that. If the government wants to give, why should we come in? A family is being benefited, why should we come in? The life factor is that.
Anyways, Because they've been the benefit.
One last
Yes.
submission.
Yes.
Since the question of employee, giving them the 1970 rules has come out, my lord. There's one citation which says that wrong decision does not create a right. Though we have already committed a mistake, but there is no question of negative equality. And I have submitted my citation 2009 12 SCC 49 at para 11.
Yes, a lot of things have gone underwater when this, you finally decided to challenge the 2015, isn't it? Anyways, anything else to submit?
No, ma'am.
Heard Mr. Victor L. Raghu, Learning Council for the petition, along with Mrs. Linda L. Comber, Learned Additional AG for the state of Congress. Hearing is complete. Matter is reserved for order.
Item 18.
This nonsense.
Yes.
You do one thing, all these slides, you keep it, madam.
Or you put it in.
With madam, I'll take my advice.
Yes.
Okay.
I also want one.
May it please, my lords. My lords, the affidavit on behalf of the respondent number 1 was filed on 20th August 2024, my lord. And if I may kindly draw your attention to page 27 of the said affidavit, my lord. Paragraph 57.
Page?
27, paragraph 57. Page 27.
Additional affidavit.
Additional affidavit, a thick one, my lord.
Page 27, para?
57, my lord. It's a very bulky affidavit, my lord.
20th, yes.
Yes, go ahead. Taking step.
They are taking steps, but now the date is now some 25. Date is 31/5/25 for completion.
So, yes, anyway, sir.
Yes, my lords. We had mentioned earlier that the expected date of completion of the work was 36/2024, my lord. But due to technical reasons and other reasons solely attributed to the department, now the tentative date of completion is 31/5/2025, my lord. So the
That
work
means
is in
1 year.
progress, and recently because of monsoon, it's difficult to work on the bridge. And now the date of completion is 31/5/2025, my lord.
Now, where have you explained the percentage of work completed by you? That was one thing that was noted.
Para 53, 26.
Page 26, para 53.
Yes, read that.
It is humbly submitted that the overall percentage of progress as on date financially is 66.78%, approximately completed all of the project where bridge proper is completed 65.35%. Copy of the RA6 bill dated 17/6/2024 has been enclosed in this, my lord. Whereas for the protection work of the bridge is 68.98, of which the last measurement sheet. So according to us, the bill has been enclosed and the percentage is 68.98%, my lord.
Yes, anything to say in this matter? Yes, the petitioner.
Lordship, since the beginning this PIL was filed,
Oh,
there was a land acquisition problem, as it is mentioned in this affidavit. Then there was a record-breaking flood, then land acquisition problem again, then outbreak of COVID-19, then flood outpour, then Assam Mizoram border issue, then second wave COVID. Then after that, supplementary agreement was made so that the work can be completed on 30/6/2024.
yes.
But now they have extended their time. So this bridge is the main source of transportation for this southern Mizoram belt. So this is going to be a problem if this is going to be extended time and again, Lordship. And this in Para 25 and Para 31, the RA RA3 and RA4 bills are pending. Just like RA5 and RA6 are pending from the state government, Lordship. And there has been a blame in this affidavit as well that it is mainly solely because of the unpaid bills which is pending from the state
Yes,
government.
so the state government,
There are no unpaid bills. We have already cleared all the bills, pending bills, as of now.
so how can we take your affidavit then?
You say your bills are not cleared?
Those were earlier facts that has been highlighted altogether. my
now
lord.
there are no
Now there are no pending bills. The bills are cleared, the work is in progress, and the completion date has also been highlighted, my lord.
But the completion date, 31/05/2025. You see,
Earlier it was
the
36.
difficulty, the problem that has been faced by the public for the non-completion of this bridge.
There's a river under the bridge, my lord. The problem is during monsoon, it's difficult to work on the bridge, my lord.
With this, anything to say? Do you want to verify? Or anything?
Yes, Lordship.
What?
If I may given at least 2 weeks time to verify this.
Heard Mrs. So-and-so, learned counsel for the petitioner, along with Mr. Samuel L. Sanke, learned counsel for, you're appearing as the.
Counsel for the respondent number 1. I had taken up this matter before I joined
Okay,
the government, my lord.
learned counsel for respondent number 1.
One.
And Mrs. Linda L. Fumble, learned additional AG for the state respondents. The learned counsel, the respondents number 1 have filed their additional affidavit wherein it has been highlighted at para 53 regarding the completion, the percentage of completion of the works as under, okay, para 53, copy paste. It has also been submitted that though the work was expected to be completed on 30/06/2024, but due to technical reasons and other reasons solely attributable to the department. What is this other reasons?
The bills that was not cleared early on, my lord.
Which is that the bills were previously not cleared by the department. The tentative date of completion is now said to be on 31/05/2025. Mrs. Linda L. Fumble, learned government advocate, submits that as of date, there are no pending bills. And therefore, there should be no hindrance in the continuation of the works for the completion of the bridge. What is it? Where is it?
Which
Bridge.
river?
Yes. What was the term used? We know where it is, but
It is in Para 2, Lordship.
Zamwang Road.
Pairabi to Zamwang Road.
of the BUSD bridge within brackets 80 MTR span, close bracket, over R Tere at CH 7.00 KMP on Bairapi Zwangtui Road, which was estimated at a cost of comma 76, comma 64, comma 257.00.
But that was increased. That was revised.
Okay, yes.
That was subsequently revised.
Which was-
Revised to subsequently.
Subsequently revised to, where? Do you know?
Yes.
Huh? Yes, where?
Para 14, Lordship.
14. ₹2, 21, comma 75, comma 29, comma 765.43. Mrs. So-and-so, the learned counsel for the petitioner, prays for time to file a reply to the additional affidavit filed by the learned counsel for the respondent number 1 by submitting that she may be given time to verify the said facts of the instant additional petition. Accordingly, this after 2 weeks.
Obliged, Lordship.
Obliged.
Item number 19.
Okay. Yes,
Lordship, this is an appeal challenging the impugned judgment order 24 May 2024, Lordship.
yes, on May 2024.
24,
Yes.
Lordship.
And when was the, yes, and the appeal is filed when?
22/8.
The appeal, it was filed last week, Lordship.
Last week,
Last week. It was within time, Lordship.
is it?
Lordship. 90 days is there, Lordship.
90 days.
90
days.
days.
This is
See,
a
you're
writ
filing
appeal.
in a writ appeal.
Intra-court appeal. 30 days time. Where do you get that 90 days prescription?
We were the impression it should be 30
Lordship,
days.
30 days.
So,
Oh, Lordship,
yes, you
you may,
have to file an
you need to file a first, Lordship.
condonation
Maybe so.
application. Isn't it?
Maybe wrong conception, Lordship.
The registry also may have missed out. 30 days is the outer limit.
Lordship, Lordship. Sorry, Lordship.
Heard Mr. So-and-so, learned counsel for the appellate, who submits that he may be allowed to file, or we will, will we be allowed to file an application for condonation of delay in the instant writ appeal. Accordingly, this is matter of 3 weeks.
Obliged, Lordship.
Item 20.
Yes. This is a jail appeal. This is a jail appeal filed against the judgment and order dated 17/07/2023 and against the sentence order passed on 18/07/2023, wherein the appellant was convicted under 302 IPC and under section 25 within brackets IB within brackets small a close bracket Arms Act in criminal trial number 927/2017 arising out of Boncon PS case number 78/2017 by the learned Court of Additional Session Judge -1 District Court Aizawl. The appellant on conviction was sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 with default clause of simple imprisonment for 1 year. To suffer another
Fine of 1,000.
let's see the sentence in part, because we're taking the short thing. What is the last sentence?
Page. Last but one page. Pay a fine of rupees.
Wait, rupees 5,000 and in default arrive for 1 month on his conviction under section 302 IPC.
Yes, I know.
No, it's our 111. Yeah,
Oh, the top one.
yes. On his conviction under section 302 IPC and on his conviction under section 25 within brackets 1 capital B close bracket, then within brackets small a of the Arms Act of 1959. He was sentenced to undergo SI for 1 year and pay a fine of rupees 1,000 IDs SI for another 10 days. The appeal is admitted. Notice is to be issued to the respondents. Ms. Linda L. Pamban, learned PP, accepts notice on behalf of the state respondents. Requisite extra copies of the said appeal is to be duly furnished to the learned PP. LCR is to be called for. List after 3 weeks. Yes, since this is a jail appeal, this court find it fit to appoint, yes. This is legal aid counsel.
Tilal Zakima is in.
Yes, Tilal Zakima. Learned counsel as amicus curiae. Yes.
For order, item 24.
Yes.
Yes, my lord. This is an application filed under Section 5 of Limitation Act 1963 in filing the connected memo of appeal against the judgment and order dated 26/3/2024, passed in WPC 2021.
Yes.
WPC number
Yes,
21
will you
of
notice, will you
2020.
notice?
Yes, my lord.
Heard Ms. Vani Isyami, learned government advocate, who has filed the instant state appeal against the judgment and order dated 26/03/2024. passed by the learned single judge in WPC number 21 of 2024. Wherein the condonation of a delay of 118 days has been sought. Issue notice to the respondents to registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Item 26.
My lord, may I seek indulgence in item 24? I am appearing for the appellant.
Okay, we had mentioned that you were absent.
Yes.
Okay, Mr. Lalpriant Fellow Chongto, learned counsel for the appellant is present. It is seen that paper book is received. Requisite copies of the paper book is to be duly prepared and furnished to both the parties at the expense of the appellant. Yes. Then I think we have set list after 2 weeks or something. Yes.
26.
Yes, my lord. Regarding today's case, I did not receive any instruction about the clarification of some orders. So if I may be given another 2 weeks' time to get the clarification.
Mr. Newly appointed government advocate. And in the last court date,
We had asked for something.
you had paid for some time to study the case.
Yes,
isn't
my
it?
lord.
Heard Ms. Van Isiami, learned government advocate for the state respondents number 1 to 2. The learned government advocate has prayed for further time to prepare for the case. Okay. Which is not objected by Mr. Victor N. Ranko, learned counsel for the appellants. In view of the above, list after 2 weeks.
Item 28.
Obliged.